30 years ago, if anybody had asked what a cookie was, the answer would be an American biscuit. If anybody had asked what spam was, you might have thought of a particular television comedy show if you were in the UK, or if you come from other parts of the world and you wouldn't understand this funny British humour, you would think it was a meat product that when you were at school you tried to avoid. And a new hard drive was on the market for the first time, boasting a massive 10 megabytes world-changing volume. Fast forward 3 decades nearly, World Economic Forum in 2010, 2011, best estimate of the figures. People around the world send 47 billion regular emails, share 30 billion pieces of content on Facebook every day, and send 95 million tweets. And I have joined those who now do all of those things, and I do my own tweets, just in case you wonder. And if you have any objection, then you have to complain personally. I'm just working on getting my number of followers up to that of Stephen Fry, who's also a Cambridge graduate. He's on 7 million. I started in November. I'm up to about 5,500, so I just need a really, really good thing to say. And I might do a quick surge forward. So if you make me say something absolutely exciting or you say something wonderful, perhaps we'll move very quickly. Lots of things are happening. We've seen in the last year the European Court of Justice landmark ruling on in the Google case. Come back to that in a second. We in the UK are considering changes in the Data Protection Act that's now dated 30 years ago. We've launched a call for evidence on the balance of competence in information rights between the EU and the UK. I'll come back to that too in a second. And the European Commission has been looking at safe harbour. I welcome people here from the European Commission and from other member states. And the Council, the other day at the meeting in June, reached a partial general approach in that regulation. It's absolutely no wonder that concerns about data protection and freedom of information and privacy are on the rise, but I'm very clear that the benefits of the sort of communication that free internet and the digital economy give are phenomenal in terms of economic growth, in terms of society generally. I went to Estonia for the first time last year. The more access people have to information wherever they go, it seems to me the easier life is and the more valuable it is. People of my godson's age, Will's age, and all of his peer group at school, and younger people in my family and your families rely on the new information systems to be able to be well equipped. We use it on a regular basis, including night before last, to check exactly how many people live in Costa Rica. The task for all of us, not just government, is to make sure we get the right balance between the benefits and the need to preserve privacy and data protection. That's the challenge. Of course, it's difficult, but I hope collectively, with your wisdom, knowledge, experience, this sort of conversation and the regular conversations that ministers like me and colleagues have, we are arriving in the right place. So let me quickly try to address the issues that are on our agenda. Priorities. Firstly, to examine the balance of competences between the UK and the EU. Let me say a word about that. We expect to publish our balance of competences report by the end of the year. We're doing this across the whole of EU-UK legislation. It's not meant to be a political steer. It's meant to be an assessment of where we are at, what people really think of where the power lies. Is it held in the right place? It's the balance of legislating responsibility in the right place. We want a comprehensive assessment of what the EU does and how it affects the UK in the area of information rights. We want the analysis to be objective, impartial, and as evidence-based as possible. And we want it to promote public awareness of the area and participation in the debate about the future. We have sought to gather as much evidence as we can from all obvious stakeholders. We've had workshops in London and Edinburgh and Belfast and Brussels. We've contacted 300 organisations, officials, academics, practitioners, civil society representatives. And for those of you who are thinking, I knew nothing about this, worry not. You are just in time to make your submission. I mean just in time. The published deadline is midnight tonight. So in that little gap when you, I see on your programme, could go punting, always very desirable. especially if you're not having to do the punting, then you could send in your submission. I guess that we, being a generous nation and a wonderful government, if you slipped it in a day or two late, would nonetheless consider it. But seriously, if you do want to submit a view and you haven't, please do that. We would welcome that very much. Secondly, looking at privacy and data protection rights, we're taking action already to strengthen the privacy and data protection rights in our own UK legislative context. We have announced that we are putting an end, as of December this year, to enforced subject access requirements. Really important. People are often misled into revealing things they don't now have to reveal. I'm very proud that we as a government have just changed the law for the first time since the 70s in terms of what you have to disclose in terms of previous convictions to rehabilitate more people. Not obviously for the most serious offences and not where there's a vulnerable context for your prospective work, but for people who as teenagers may have done something wrong. It's really important you can come past that and come out the other side, and we therefore need to make sure enforced subject access requests are dealt with, and employers no longer can force prospective staff to put in that sort of request and disclose the results. So that will be good, it will become a criminal offence from December.